Hello, my name is Ted Meyerson. I'm a volunteer with AARP Maryland, and I'm really thrilled today to have the opportunity to talk with Muriel Vanderberg, who is from the Senior Legal Services, about advanced planning. And I'm going to ask Muriel to talk a little bit about Senior Legal Services and about herself, and then we'll talk about advanced planning. Muriel?
Thanks, Ted. I work as an attorney for Senior Legal Services. We are a nonprofit based in Baltimore City. Our mission is to assist city residents age 60 and over with legal matters. And a lot of what we do for our clients is advanced planning so that they can feel comfortable that things are taken care of and things will go the way that they want them to in the future.
So that's what advanced planning is, Muriel?
Yep, advanced planning is putting in place some legal documents that are going to address the issue of what would happen if you become incapacitated and can no longer make medical decisions for yourself, and who would manage your money if you become incapacitated and can't manage your own finances. And finally, what will happen and who will inherit from you after your death. It's never too early to start with advanced planning. I think every adult should go through this. But it is sometimes too late. We have clients who come to us, or potential clients, and they no longer have the sufficient mental capacity to be able to understand the documents and to be able to execute them. So it's never too early, but it sometimes can be too late.
So, Muriel, what are the documents? What are their names?
So a basic estate plan consists of 3 documents: a last will and testament, an advance directive, which is going to address medical issues, and a financial power of attorney.
Okay, so tell me what a will does.
So a will is a document that you're going to execute that will tell your family and friends, first of all, who would be in charge of your estate after your death. That person would be called your personal representative, sometimes known as an executor. And the will also state who will be inheriting your assets after you die, at least the assets that will be passing through your will. If you have children, one of the things you're going to want to address in the will is nominating the guardians that you would like to see appointed for your minor children.
For minor children?
Yes.
Okay. Do I need to appoint somebody to take care of say, my wife if I were to die?
No, you would if you had been appointed the legal guardian of your spouse for some reason. That could happen in a situation where where your wife didn't have the proper advanced planning documents in place, and she survives you, and she doesn't have sufficient capacity to address things in her daily life by herself. If in that situation, you would want to name as a potential successor guardian to yourself for your spouse.
So that'll take care of a will. But what is this thing called an advance directive? I've heard of that, but I don't know what that is.
An advance directive is a document that you'll put in place in which you're going to state foremost who would make medical decisions for you if you become unable to speak for yourself. Imagine that you are in a car accident, and for some time you're in a coma. And during that time, you're not able to answer the doctor's questions about what kind of care you want. If you have an advance directive in place, the medical staff can go to that document and see who is authorized to make those decisions for you. In an advance directive, you're also typically going to give some information about your types of medical treatment that you would like, particularly end-of-life types of medical treatment. It can address other issues as well, but those are the primary, that you appoint someone to make decisions for you, hopefully also a backup person, because sometimes the first person is not available, it can't be reached. and also that you give some instruction as to how you want medical things decided for you after you can no longer speak for yourself.
Okay. I mean, that makes good sense. So if I were to have this advanced directive, I ought to keep it in the same place, safe place, I guess. So I'd keep it in the safe deposit box with my other stuff.
An advanced directive is meant to be shared far and wide. Photocopies are legal. Once you sign and execute an advanced directive, you're going to want to give a copy to any persons you named as your agents or your backup agents. You're also going to want to take that document to any physicians you see regularly. I recommend hanging a copy of that document on your fridge, giving a copy to your nosy neighbor. It just should be spread far and wide. Unlike the other two documents that we're talking about, those are more to be kept private, but that advanced directive you spread far and wide. And as I've recently learned, there's also an opportunity to upload that advanced directive to a website called mydirectives.com. And if you do that, it will become part of a system that can be accessed by physicians and hospitals throughout the state of Maryland. So it could be found in the case that it's needed.
Wow, that's interesting. So how would I make an advanced directive?
So there's a couple ways you can do it. It's sort of a forgiving document, unlike a will and a financial power of attorney, which are, really need to have certain elements in them. An advanced directive, at our office, we use the Maryland Statutory form. We find that to be a decent form. It's available on the Maryland Attorney General's website, and it's very functional. You can also, as I've recently learned, go to mydirectives.com and make a video advanced directive if that's more your speed. There's lots of options. The important thing is if it's a written document that it's going to be witnessed by two people who are not the agents. And at least one of the people signing that, witnessing your signature on that document, needs to not have a financial interest in your death. So it's just a document you've got to get done, because you never know when you might lose the ability to speak for yourself in medical situation.
That sounds pretty expensive.
Well, the statutory form is free. I do think doing it with an attorney can be beneficial, because they can help you think about some things that you might not think about yourself. So, I think one way to go is to go and see an attorney and have them prepare it for you. Sometimes when you go in for medical care, medical staff will assist you in preparing one, but you can do your own. And it would be perfectly legal if it's properly executed.
Properly executed. You push me on that one. What does that mean?
So again, if it's in writing, it's going to have when you sign it, your signature needs to be witnessed by two people. Again, they should not be the agents named in the document, and at least one should not have a financial interest in the document in your death. That's sort of the old school way of doing things. The witnesses now, the whole witnessing operation can be done remotely now. That has come about since the pandemic. And also, again, if you go to the mydirectives.com website, there is a way to create an advanced directive there without witnesses, because that website will verify your identity in another way. So that'd be another option.
Wow, that's all very interesting. So tell me now, we had talked about a will, and now we've talked considerably about advanced directives. That's very, very interesting. But what about this financial thing?
So the third document we're often doing with clients is a financial power of attorney. So with the advanced directive, we were naming someone to make medical decisions during your life if you cannot speak for yourself. A financial power of attorney is going to address who will make financial decisions for you. A power of attorney can take effect immediately, meaning you sign it and the person that you name to make the decisions could start using it right away to do things for you. Or you can make the power of attorney contingent on some condition before it can be used. Language that we often put in a power of attorney to give people a little bit of protection is that a power of attorney cannot be used by the agent until the person signing the document has lost mental capacity as confirmed in writing by a physician or a licensed psychologist.
Okay.
So the financial power of attorney is the reason to put this document into place is if you don't have it and you suffer that car accident and you're in the hospital for a long time. The question is, who's going to pay your bills? Who's going to interact with the insurance company? Who's going to deal with any litigation that results from the accident? If you have a financial power of attorney in place, the agent that you've named in that document, or the successor agent, because you're usually going to name a backup as well, they can step up and help you with those things. Now, I will say that sometimes we meet a client who simply does not have a person in their life whom they have sufficient trust in to manage their money, that they feel comfortable doing a financial power of attorney. So sometimes we end up not doing that document because the agent you name in a financial power of attorney will have a tremendous amount of power over your money. And sometimes that power is misused. So you really have to pick your agent carefully and really know that they would manage your money in your interest only.
Wow, that sounds like very risky business to make all my assets available to somebody else. Is there any protection for me there? Can I do anything to safeguard that somebody's not going to steal it all?
Well, your main line of protection is picking a good agent to begin with. If you still have capacity and you see the power of attorney being misused, you can revoke it in writing and make sure that you spread that revocation around to any parties who may have been presented with the power of attorney, including the agent who's using it. But I think you also there is some risk. There is risk to appointing someone to manage your money. And that's why you can also put in that language that says the power of attorney can't be used until you really, truly cannot manage your own money. But there's also risk to not having the power of attorney in place, the financial power of attorney, because if you don't have such a document in place and you can't manage your money anymore, the only alternative that your family has to manage your money for you is to apply to become your guardian through the court system, the guardian of the property. So it's if you execute a financial power of attorney, you pick a good person, you put some protections in the document as to when it can be used. It's a really great tool to avoid that eventuality of having to have a court-appointed guardian take charge of your money.
Well, who's going to determine that I can't take care of my money?
So the standard language that we use says that the power of attorney cannot be used unless it is accompanied by a written certification from a physician or licensed psychologist that I can no longer manage my money effectively under the definition of the laws of the state of Maryland. So that's a pretty good protection. A physician's going to have to determine that, your mental state is such that you really can't do it for yourself and put that in writing. And that would then have to be attached to the power of attorney before it could be used. So there's that protection.
Okay, so we have spoken about wills, which tells people the physical things that you want to give away and to whom. We've talked about a financial document, which would give somebody the authority to use my bank account and to sell my stocks or bonds or my home or anything,
Correct.
right? And we've also said there's an advanced directive, which is supposed to take care of medical questions if I can't talk, if I can't speak. Um, does that, who determines that? How does that go into play?
Well, it's physicians are going to determine if they're not able to get a response from you, then at that point, depending on exactly what the Advance Directive says about what documentation the physicians need to make before moving on to your agent. But if the criteria are met, then the medical staff can move on to the agent named in the document. If you haven't done an Advance Directive and you haven't named an agent, then the state of Maryland has a list of agents in order of priority named for you. So if you want to maintain control over who's going to make medical decisions rather than have the state sort of decide who that's going to be, best do an Advance Directive and put it in writing or put it in a video and upload it to the mydirectives.com website. Make it clear.
Well, I don't understand. I just want my 4 daughters to make decisions. What's wrong with that?
So that's a great example of a situation where if you don't have an Advance Directive, there could be trouble ahead. Because your 4 daughters, assuming you are widowed, no longer have a spouse, they're going to have equal priority to make medical decisions for you. And unless you have a guardian as well, that would be the only person ahead of them. And if they don't agree, the 4 of them, on what is best for you medically, then they'll have to go to court to decide who is the ultimate, what is ultimately going to happen to you. If you have an Advance Directive in place, you can say, Susie's number 1. She's backed up by Angie. She's backed up by Joni, and she's backed up by Jeanette or whatever. And you reduce the fighting, the pressure on the family. It's just really clear who you wanted to make that decision primarily and who the backups are. And you avoid that situation where people of equal priority could start fighting about what's best for you.
So only medical things can go in an Advance Directive?
It can address other issues too, like what kind of religious things you'd like to have happen in end-of-life situations. It's very broad. You can really put a lot of direction in it as to how you would like things to go, what music you would like to be, playing, or things like that. You can be pretty specific. We do not get into that with our clients. We really do the basic form, and there's an opportunity on the statutory form just to say a little bit about what your end-of-life goals are, what would be most important to you. We sometimes fill that in for clients, but usually my clients are pretty content to name their agents, go through the second part of the document, which walks them through 3 end-of-life scenarios and lets them give some guidance about what they would want in those scenarios, and leaving things at that.
That's fascinating. So let me ask you this. Suppose somebody is Eastern Orthodox and wants to have an Advance Directive that is specific for Eastern Orthodox. Can they find one?
So if you go to the Maryland Attorney General's website, there may be some links there to get you further along to a document that might reflect some of your values and beliefs more specifically, but you could certainly create or find a document tailored to your religious beliefs. That's definitely possible.
That sounds wonderful. I'm out of questions. Do you have anything else you would like to add to this?
I do. I think as part of advanced planning, so in addition to putting these 3 documents in place, there are some other things that you can do to make things really easy on your family. For example, if you own a car, and it's a lot of married couples have, for example, have a car in the name of just one of them, and not the other. One of the things you can do for a car is to name a beneficiary, a vehicle beneficiary, who will receive that car upon your death. You can do that through the MVA website, and there's also a way to do it on paper and not through the website. But if you name a beneficiary, and you can do this even if you still owe on the car, it will just make the transfer of that car so much easier after your death. Essentially, the beneficiary would just go to MVA after your death with your death certificate, and the car could be retitled more or less instantly. In many cases, even the inspection is waived. So that's a really great thing to do for your car. Make sure you name beneficiaries for your financial accounts. And we're all prompted to do that. For example, if we open a life insurance policy, or if we have a 401k, we're sort of hounded to name our beneficiaries. But it's lesser known that you can also name payable on death beneficiaries for your bank accounts. Banks don't publicize that, but you can. And that would make the passing of any money that you die with very, very easy in your bank account. The beneficiary, again, would just go to the bank with proof of your death, and that money would pass easily to them, rather than the alternative. If you don't do the MVA designation, the beneficiary designations, all of that money will pass through your estate, which would require opening an estate and going through the estate administration process, which can be many months long, sometimes years. So those are some basic tips to make things easy on those you leave behind.
We do have one question that has come in, and that is, what age should I start looking to begin advanced care planning? I am early 20s.
I think that's a great age to do some planning. Definitely to do the 2 documents that relate to incapacity. I mean, in your early 20s, you may have very little or no assets, so a will may be a little less important right at that moment, but you certainly run the same risk as all of us of having a medical crisis where you can't speak for yourself or manage your money for some time, or maybe perpetually. So it's a great time to do it in your early 20s. In fact, I brought this baby hat. I saw it this morning in my room, and I'm reminded that I didn't get around to advanced planning until my first child was born. But that was much too late. I could have had a major medical crisis before then, and I had assets, and who would have paid my mortgage, and who would have managed my money if I didn't have this document in place? So I'd say do it as soon as you're an adult, and then keep it up to date. Review it every few years. Make sure it's still reflecting. Make sure the documents are still reflecting what you wish to have happen as things change in your life.
If I remember correctly, all of the major advanced medical problems happened to women who were under 30. Mary Ann Quinlan, and there were 2 others. And one of them went to the Supreme Court. I forget which one, but they were all young women. And so, I mean, that just reiterates what you just said. It's if you're old enough to drive and old enough to vote, you ought to think about an advanced directive, it would seem to me.
I agree. I think the one thing one thing I'd like to touch on as well is the Advanced Directive doesn't address a situation like a dire medical crisis. For example, if you're in if your heart has stopped beating, the EMTs or the hospital personnel will revive you, whether or not your agent under the Advance Directive is saying, hey, she wouldn't want that, please don't revive her. The Advance Directive just doesn't extend to that situation. If you want to address those types of medical events, such as resuscitation and some other sort of dire events, then you would want to discuss with your physician or your nurse practitioner the medical order for life-sustaining treatment. It's not something an attorney can do. It's not something you can do by yourself. But in that document, which would become a medical order in your file, you can address issues of what, would you like to be resuscitated, and what your other requirements would be in a really dire situation. Because again, the Advance Directive is not going to extend to some of those situations.
Very interesting. Somebody said, my son is turning 18. Should he have an Advance Directive?
Yes, because he is an adult, so he needs to have that in place. Now, if he doesn't, the surrogate decision maker in that situation, unless he gets married, is going to be a parent. But it's just a great discussion to have with him. Who would you like to make medical decisions now that you're an adult? And can you tell us a little bit what your thinking would be in certain situations, and get your son thinking about those issues, and then put them down on in a legal way.
Well, I think we've covered an awful lot of information. I'd like to go back to the senior legal services for just a moment. You said that's Baltimore oriented, but we may have people watching this from all over the state or even further. What should they do? Could they call senior legal services and maybe get a referral of some kind? And can you give a phone number that, if that's what you agree to, that they might reach senior legal services?
Sure. Our office is always happy to take your call. And if you're not a city resident, age 16 over, to direct you the best we can to an alternate provider, an alternate resource. Our phone number, our intake phone number, is 410-396-1322. 410-396-1322. And I would say, if you, we do get a lot of calls, and we have just one person. We're a very lean machine. We have one person sort of manning that intake line. So sometimes it is hard to get through, but keep trying, because we will get to you. And when you get through to us, you will get good advice.
This has been wonderful. I want to thank you very, very much for what you've done today, because I learned a lot, and I know that people watching this will have learned a lot, and we owe you a lot. So
it was a pleasure. Thank you for inviting me.
Oh, anytime. Thank you again. And I'll say bye to all.